Good morning, good afternoon, good evening, or much will depending on your location. Please join in the struggle to liberate our people from the contraption. Like and share videos. News update. Supreme Court fixes December 15 to deliver judgment in the case filed by the federal government against the judgment in favor of Nnamdi Kanu by the Court of Appeal. Now, the Supreme Court on Thursday fixed December 15 to deliver judgment in the appeal filed by the federal government against the Court of Appeal judgment that quashed the criminal charges preferred against Nnamdi Kanu and ordered his release. Now, Justice Kudirat Kekereku fixed the date after taking argument from Nnamdi Kanu's lawyer Mike Ozekome and Tijani Ghazali, who represented the federal government. Yes, the federal government, while presenting its case through their lawyer Ghazali to the Apex Court, the Supreme Court, appealed to the Apex Court to void and set aside the judgment of the Court of Appeal, which voided the charges preferred against Nnamdi Kanu and ordered his release. Now, Ghazali pleaded specifically to the court, saying that the judgment of the Federal High Court in Abuja, which upheld 7 count charges against Nnamdi Kanu, be affirmed so that Nnamdi Kanu can be brought for trial in the charges. But opposing the federal government, Nnamdi Kanu's lawyer, Chief Mike Ozekome, maintained that the federal government has since June 29, 2021 been detaining Nnamdi Kanu illegally, unlawfully, and unconstitutionally. Now, Chief Mike Ozekome pleaded that the judgment of the Court of Appeal, which quashed the entire charges against Nnamdi Kanu and ordered his immediate release, be upheld and affirmed. He maintained that Onyendu's controlled detention by the federal government was unlawful in the face of the subsisting Court of Appeal judgment, which had ordered that the leader of the IPOB be immediately released unconditionally. He insisted that no government has power to trample on the fundamental rights of citizens, as in the case of Nnamdi Kanu. Ozekome maintained that Onyendu is being detained in gross violation of both local and international laws. He therefore urged the Supreme Court to uphold the judgment of the Court of Appeal and order the immediate and unconditional release of Nnamdi Kanu. You will recall that the Court of Appeal Abuja Division had on October 13, 2022, in a judgment in an appeal filed and argued by Chief Michael Ozekome, dismissed the remaining 7 count criminal charges brought against Nnamdi Kanu by the federal government at the High Court in Abuja. Of course, the Ghazali, the counsel representing the federal government, is making reference to this particular judgment. Yes, but the appeal court judgment of October 13 quashed all this. Of course, going forward, in an appeal against the High Court ruling, the Court of Appeal, while upholding all arguments and submissions of Chief Michael Ozekome, quashed the entire 15 count criminal charges. All. Now, the appellate court agreed with Michael Ozekome that the federal government violated rules of engagement in the West and manners. Onyendu was abducted in Kenya and brought to Nigeria. Specifically, the Court of Appeal held that the Nigerian government broke the international laws and resorted to self-help in its failure to file extradition charge against the IPOB leader in Kenya instead of resorting to unlawful abduction and rendition. Now, the panel of the 3 justices of the Court of Appeal, in allowing the appeal argued by Ozekome, had ordered immediately and unconditional release of Nnamdi Kanu from the custody of the Department of State Services. The court also prohibited the federal government from further detaining or prosecuting Nnamdi Kanu on any indictment or charge before any court in Nigeria. Apparently dissatisfied, of course, with the appeal court judgment, the federal government, led by Muhammadu Buhari then, took the case to the Supreme Court, requesting that the Supreme Court should quash the findings of the Court of Appeal and restore the trial of Nnamdi Kanu on treasonable felony at the Federal Court. You don't see him. Now waiting be this. Now waiting the federal government they do. So the Federal High Court had in an earlier ruling returned 7 counts out of the original 15 counts against Nnamdi Kanu after striking out 8 out of the 15 count charge. Alright, Justice Binta Nyako, while striking out the 8 charges, had heard that Nnamdi Kanu had questions to answer on 7 other counts. But both the 7 count and 15 count, the Court of Appeal quashed it on October 13th. Put together the 15 count charges, all the appellate court quashed all of them. Discharged Nnamdi Kanu, free, discharged and acquitted. They declared him so. So nothing was left unattended. All of them was quashed, the 15 count charges. So December 15 has been set aside for this judgment. And this is October. Is exactly 1 year. Nnamdi Kanu was discharged and acquitted. October 13th will make it exact 1 year. He was discharged and acquitted. And we are talking about 15th December to deliver judgment. Well, let us feel, be optimistic that by December 15th, the Supreme Court will do the needful, because you have seen how it was clearly stated that the federal government violated rules. You have seen it here. They were on self-help. You recall when Malami, the then Attorney General of the Federation, said, "Oh, we have brought Nnamdi Kanu back." International community, why many Nigerians, Igbo people, everyone was asking, how manage? What was the modus operandi? Up until he left office, he never provided, evidence or outlined the processes, they adopted to bring Nnamdi Kanu back. He never did it. So he left people in the dark. But of course we know that Nnamdi Kanu was abducted, forcefully, extraordinarily, brutally conditioned after being tortured in the soil of the Kenya and brought back to the country. Forcefully, while on transit, he was being tortured, even in DSS here where he was clamped. Still undergoing torture until the head had, abdicates office. As we are speaking, it's not even better. Torture is still ongoing. So what are we not talking about? They should do this fast and release this man. They are detaining him unlawfully, illegally. And that is why we are seeing all these issues coming up in the Southeast. Anybody who is detaining Nnamdi Kanu unjustly, illegally up until this moment is an enemy of the Igbos, enemy of Biafrans, enemy of Southeast people. Both the household enemies, they are there, we have seen them. Both international enemies, both national enemies, they are there. If your hand is in detaining Nnamdi Kanu to this moment, you are enemy of the Igbos. Be you who, no matter where you come from, know this.